We now know how easy it can be for COVID-19 to spread from person to person, but what happens if someone spreads it on purpose, or if a business has an outbreak because they weren't following the rules? ABC 10 News reporter Jared Aarons went in depth with a legal expert to get answers to some of these criminal questions that surround coronavirus.
San Diego County leaders have stressed education over enforcement when it comes to the rules for coronavirus for businesses and people. But there are some laws they can use to help stop the spread.
One is civil liability and the other one is criminal liability.
Joanna Sachs is a professor at California Western School of Law, specializing in laws on science. She says rules for communicable diseases revolve around a term called reasonable care.
But as long as you are taking precautions reasonably, then it's unlikely that you'll be held negligent. That would be the legal term.
For businesses, that means doing things like posting and following safe reopening plans.
So if you have masks provided, hand sanitizer, and you're using reasonable care to take care of your employees and their surroundings, then your risk of liability is low.
But when a business blatantly ignores the rules, local leaders have shown their ability and willingness to use the law, like here at Boulevard Fitness in University Heights. It closed in August after City Attorney Mara Elliott threatened $2,500 in fines for each day it broke the rules on indoor activity. The city's letter said the gym had been illegally open for 45 days, engaging in unfair business practices. Sachs says those kinds of fines are good for extreme cases, but not smaller violations.
If businesses are not behaving reasonably and they are behaving recklessly and they have no plans and they're letting people in, that maybe they should face liability. Those aren't the businesses that should be open to the public because they're doing a disservice to the rest of the community.
When it comes to one person infecting another, California law is strict and hard to prove. Section 120290 of the California Health and Safety Code says 5 things all need to happen for someone to be guilty of what's called intentional transmission. 1, the defendant has to know they're infected. 2, they have to act with specific intent to transmit the disease. 3, they have to engage in conduct that poses substantial risk of transmission. 4, they have to actually get someone else sick. And 5, the person infected can't already know the defendant is sick before interacting with them. It's a misdemeanor, punishable by up to 90 days in jail, but it's not the only legal statute a person could face.
You can also be reckless and you can have depraved indifference towards human life. And those don't require intent. It just requires exactly what it sounds like, recklessness, depraved indifference. Like, I'm infected and I don't care. I'm going to go out and live my life.
Over the summer, protesters in San Diego told ABC 10 News coronavirus rules requiring masks and social distancing are a violation of their liberties and freedoms. For that, Professor Sachs compares it to driving a car. When you get behind the wheel, there are rules for things like wearing your seatbelt and also obeying traffic lights, speed limits, and signs. But we also drive safe just to protect each other and because it's the right thing to do. Sachs says it's the same with coronavirus. When you go out, there are rules to wear a mask and social distance. You may not get a ticket for breaking them, but it's still part of our social contract to keep each other safe.
Part of our liberties actually require that we cooperate with each other. And so the law can get us part of the way there, but it can't get us all the way there.
When it comes to civil courts, Professor Sachs told me the same basic standards apply: intent and reasonable care. But she says the best thing people can do right now is wear a mask and take care of each other. Jared Aarons, ABC 10 News.